Hi Shreya, if you could switch on your video. I think I have put up a tile view for both of us. Yes. Hi.
Hi. Hello.
Hi. We have about 20 plus participants, so I'll start quickly. Thank you everyone. Good afternoon for joining this session. So this is a focused 45-minute deep dive into the DPDP landscape. So we are actually very privileged to have Shreya, a partner at Induslaw, with us. So I'm going to first introduce her in very briefly, and then kind of set up the idea, right? So Shreya is a like a powerhouse in the TMT, data protection and fintech space. She's taken a lot of recognitions across, Chambers and Partners Asia Pacific 2025. She has all sort of awards. I think I'll probably skip some of them, but yeah. So rising star, up and coming partner. So her background is unique. So she bridges a gap between legal, as in high level regulatory advisory, and also she has been part of the Supreme Court and High Courts as well in India. So we know your prime time is a premium, so I'll very quickly start. I've been telling the team, so as in the attendees, so we have only 3 points. So one is it's a Q&A session, so have an interesting format in our opinion. And two is we have a Q&A open for all of the people, all of the participants. In case you have any question, they can feel free to kind of put it in the system. So we were running a small poll till you kind of got into the system. So that's where we are. Can we start? Chair? Yeah.
Yeah, we can start.
Great. So to kick things off, we all have our own understanding of DPDP, right? I think, at least and when I say that, I'm speaking on behalf of everybody else, right? So I think what we would like to probably start with is your definition or how you see DPDP in a shorter answer to start kick off the session. Yeah.
Sure. Thank you, Yuvraj. I personally see DPDP as quite a development in the Indian data protection landscape, for one. I think all of us are very tired of getting calls from telemarketers, from insurance companies that we never even heard of, and we keep wondering, where someone has gotten our information from. And it's high time that, there is some action taken to put a stop to these things, at least going forward. I mean, of course, not there's not much control over what has already happened, but I do see this law as a means to be able to correct, or rather course correct, what has happened so far. And we do know that even historical data gets covered by law. So everyone who has access to your information is mandated to kind of either retake consent if they've not taken it in the past, or at least give you a notice allowing you to exercise your right to withdraw consent. So that is what I see this legal framework as a course correction, but also it will help us question and think about what privacy means to each of us as individuals. Aside from organizations, aside from businesses. But even at the organization level, I do feel that the only way this law will work and the only way we will effectively be able to enable compliance is by driving privacy as a culture within the organization. So that's why it becomes relevant and important to my mind.
It's an interesting take for. I'll try and summarize in 2 points what I understood. So the first thing is you're looking at it largely from an individual, lens. I think that's where you started. And it emphasizes, I think, all our perspectives in terms of where we stand. One, and two is you mentioned it's a cultural change, which is very interesting. Because I think we strongly believe that as well. But probably it's most unattractive way of putting it, but I think it's very important. So
yeah, indeed. And of course it is going to transition the way businesses operate, and it's not something which I see as a deal breaker or a significant impediment to what businesses are doing, but it will just help them enable their operations, or implement their operations more ethically or aligned with privacy concepts, which is what the law really talks about. It's about being transparent. It's about being process oriented. It is about demonstrating what I mean, basically having a documentary trail to demonstrate your compliance. These are the three key pillars the law stands on.
Thanks for this. I mean, with this, I think we have actually curated a set of very tough questions. So I think it'll definitely be helpful for all the attendees today. So with that, I'll start with kind of our first question. So okay. So let me ask this. What do you believe is the single biggest misconception businesses have about DPDPA today?
Um, okay. First and foremost, a lot of businesses today think of it as a cybersecurity driven exercise. It is not just about cybersecurity. I just want to clarify that. The law requires you to interpret legal provisions, interpret your processes based on the law. It's not just about your security framework, security architecture. It is about understanding what kind of operations trigger compliance requirements and what are exempt. So the only way to do that is to legally interpret something from a governance standpoint, from a policy standpoint, from generally a legal interpretation standpoint. So that is, I think, one common misconception that people often have. And very often, we do see that the project mandates are often driven by the security teams and not the legal teams on occasion. I don't think it's a solo job. That's one thing I'd like to point out. I think it is a combined effort, and both teams should lean on each other to enable compliance with this framework.
I mean, you kind of probably went into the second question that I had, but anyways, I'll still ask that is, if you were advising a company, beginning its DPDP journey today, what should be the first practical step look like? I mean, what is the most fundamental thing that they have to start at?
Okay, fine. That's a good one and a very relevant one potentially for everyone in this room. So, in terms of where you start, uh, look, a lot of companies believe they can do a lot of things in-house. Sometimes people believe they can uh, engage just a security consultant and that's the end of it. I think it has to be a calibrated approach. For every business, the needs and requirements will be a little different. So first and foremost, if you have a significant legal team in-house and you have a significant cybersecurity team, and here I say and, not or, right? Then yes, I do believe, and these people should also have the right kind of experience and exposure. Cybersecurity team, of course, will have some level of experience, but the legal team should be the right people. If you have that, then yes, by all means, try to implement what you can in-house, and then go ahead and ask the right questions to consultants or lawyers, which are more focused, more opinion oriented. But if you don't have either of that, I would strongly suggest um, you have to at least to be you should at least be guided by someone who has done this for many companies and businesses. And normally third parties that you have heard of, or you see law firms, you see security teams and consultants out there uh, going out and working with multiple clients, so they know what the market practice looks like, they know what other people are doing. So it's definitely useful to give them a shout out to understand at least what you have to do. In terms of actually what every company will have to follow as a process, whether or not you do it in house, whether you engage someone else to do this, is to understand what are the different touch points where you're collecting personal data. Once you have identified all of these touch points, that's also what you call um, basically where all is information coming into your organization from. Is it coming directly from a user? Is it coming from some third party? Is it coming from within your internal teams? So first and foremost, map out where all that data is coming from, what are you using that information for, and whether or not that purpose that you have identified requires all the personal data that is coming to you. Can you eliminate any of these things? So this is the first and foremost exercise that every business will have to do. They'll have to understand what personal data are they really processing and why. Once you have done this exercise, then every purpose will have to be identified as either a consent-based purpose, a legitimate use, or an exempted purpose. So in order to do that, you have to get it right. And every time you're deciding not to take consent, you have to justify and appropriately document whatever it is, whatever the rationale is that you have applied not to take consent. Because tomorrow, if you get a complaint under this framework, and complaints, believe me, are going to come in left, right, center, across the board, because you don't even need a lawyer to file a complaint. So there is no barrier to entry, so to speak. Then you will have to justify what you thought, like what was your thought process when you determined the course of action that you took. So having a documentary trail is going to be relevant. And of course, once all these things are identified, actual implementation comes in, where you update your processes, you update your internal documentation, you update your external documentation, you train your employees, you sensitize them, you create SOPs. And sometimes you also take the help of tools, right, to manage whatever you have discovered, manage whatever compliance you need to do. So they make your life, of course, a lot easier, but it is very important to have something either in-house or an on-prem tool or solution that you may have, to be able to demonstrate that you are, in fact, basically all your records of compliance need to be there in one place. So that's also where your IT team comes into play. That's where legal marries, the legal function marries what the IT function does. Over and above that, of course, IT team also has to look into cybersecurity elements, but these are a few areas that you must tackle. And believe me, you will be surprised to learn where all information is coming into your company from. It could even be from exhibitions that you do or roadshows that you do. It could be from recruitment agencies. It could be cold emails. So everything will have a different way you have to look at things.
I think thanks for that. It's kind of a detailed answer. You gave probably a free of cost 10 minutes lecture on the implementation approach. Thanks for that. So I think, I'm kind of getting into a more, I would say, tougher questions to start from, right? Or rather more controversial questions. Practice, we see two different models emerging, at least from our opinion. One is there's a data office, so either there is a chief data officer, and then there is a data office, or the existing security team, like you mentioned, the information security group head by the CISO. So at least this is what we are seeing. In your opinion, what governance structure tends to work best for something that's very high on regulatory governance?
Okay, so if it's a large organization, if it's a large setup, definitely you need to have a strong team which is focusing only on this, because not only will you need the team to ensure compliance within the organization, you will also need the team to ensure that whatever complaints are coming in, they are being responded to appropriately. So they will have a dual function there. And this works for a large organization setup. So probably they will need a data protection officer, and they will need to have multiple people reporting into them or working closely with them. And every single department should also have a privacy champion. So that, or maybe 2-3 designated individuals that you identify as privacy champions, who are well trained, who know what data, who are reasonably well trained, I would say, who know what data protection means, what data privacy means in your company's context. And they should be the first point of contact for that department, or those 2-3 people within the department to reach out to if they have questions. And if that person is unable to answer, then that should be escalated to the DPO team. For smaller organizations, you will still need, see, as of today, under the IT security rules, there is a grievance officer under the SPDI rules, which is required to be there. Usually the CISO team handles that, because currently the SPDI rules are more cybersecurity oriented and cybersecurity driven. It's not, there's not a lot of legalese as such involved there in the function. But going forward, I think even for smaller organizations, having someone who is equipped both ways, from, a legal perspective as well as a cybersecurity perspective, would be a correct person for undertaking a role of that nature. And effectively, they should, and look, depending on whether it's a mid-sized organization or a very small organization, your number of issues will also vary, right? So if it's a mid-sized operation, maybe you have a legal team as well. So that person will work in tandem. If it's a very small operation with very few people, maybe you just need the one person. And especially if it's a B2B entity, you may not anticipate so many complaints. See, implementation is a one-time exercise. Once implementation happens, compliance is an ongoing exercise. So to ensure that is maintained, the person has to be equipped to handle that.
So I mean, okay. Anyway, since you mentioned DPO, it's mandatory for SDF. Let me ask this question: who should the DPO report to? I think that's $1 million question today. Yeah.
Yeah. I mean, look, traditionally, I would imagine the DPO should report to the board, uh, simply because it is, and it's a function which is independent in a way, because there is also compliance of individuals within the company that has to be monitored, right? So if there is a deviation, the DPO should be free to report that directly to anyone else. And if there is a significant violation, sometimes things have to be escalated to the board because actions have to be taken. So it may not be, and especially because it's a DPO, it's an SDF setup, it may not always be feasible to go through, 3-4 layers of regulatory red tape, because timelines are very fast. So, for example, if a breach takes place, you need to get everyone on board with what you have to do next.
Yes. Yeah. So
Yeah.
I think a lot of people, as you know, in joining this call probably is looking for that answer. So hope they got a sense of it. But I think I'll move to the next one. Again, I'll ask again as a maybe a controversial question, but still like to take your opinion. Is so GDPR came, let's say, in 2018, in the existing structure, right? So it's been almost 7+ years of basically implementation. Some
Right.
of the estimates puts the number of, less than 50% of organizations have complete GDPR, compliance, right? So meaning 50% are still not. GDPR serves as a reference point for most of the global privacy law. So from that perspective, what do you see, the compliance percentage for companies or organizations in India would be, say 3 years down the line? I mean, we're talking about 2020, May, in your opinion again, yeah.
Okay, I don't know what that number is for EU, so I won't comment on the 50%, but I do have to say that, people at restaurants also don't ask for your name, forget phone number. So they are very mindful of these things for sure. In India, my hope is that we should definitely be able to meet that compliance threshold. Look, there is a timeline, and honestly, I don't know how enforcement is going to take place, how rigorous it is going to be. Under GDPR, it's a little different, right? So companies have something called legitimate interest of the controller, which is the dictionary meaning, and not a defined term like in the Indian context.
Yeah.
So they have some leeway they can fall back on and say, look, this is in our legitimate business interest. We can do these activities XYZ. So there's a lot of justification you can provide there. Secondly, not everything is reportable at the get-go. So a company can decide, okay, is this breach significant enough? Is there going to be a risk of significant harm? Only then will I report it. In India, because that is not the threshold is that anything happens, you report. Every person, individual, will have access to a digital framework where they can quickly just file in something. So even if it's based off a rumor or a media report, someone can say something. And the minute it goes to the authority, one is, of course, the basis where the company can say, oh, they didn't reach out to us first. So how did they approach the authority without reaching out to us first? Fair enough. You may get that case dismissed. But the authority also has suo motu powers, which means they can take up things on their own. So if something has been flagged to them, if there's a media report, who's stopping them from starting an investigation into the matter? And for listed companies, this is even more problematic because the minute an investigation starts, A, you are required to disclose it everywhere to your stock exchanges, to your shareholders. B, your share price could fluctuate. There would obviously be significant reputational harm, which is common for non-listed companies also. And there is a significant trust deficit that comes in. So, yeah, I mean, I would say that enforcement will drive compliance at the end of the day. So, how robust the authority is will determine how many people, take compliance seriously. So, there's a directly proportional relationship there. But I do have to say that maybe it's not such a good idea to gamble on this because the penalties are very significant and the timelines are very strict. So you can wait and watch, or and pay the fine if something happens, or you can just pay a nominal amount to meet your compliance requirements and not pay the fine.
I mean, we'll take their opinion. Uh, so, I mean, I think the next question, I think you're better positioned to answer this as a lawyer as well, because there are some constitutional challenges on DPDP Act as a whole, right? I mean, especially in conflict RTI and the ongoing petitions as well. So, I think my question largely stems from when companies are looking at planning for long-term privacy requirements. So. Do you think this is a noise that they should probably avoid, or does it have some implications in terms of their planning?
Look, the constitutional challenges are not related to company compliances. If you see, the provisions that are being challenged are more about government access. It's more about, uh, you know, the government's exemptions really, and the requirements in terms of what the government wants to do. So, whether it is in respect of information rights, uh, or it is in relation to RTI, the name deletion. I mean, you don't need to provide personal data as part of a RTI request. So those are not directly impacting, private sector enterprises really that we are dealing with. So anyone planning for compliance, I don't. I mean, even if the constitutional challenges are successful, it will not impact what you need to do as a business. Uh, maybe just in terms of how the government may seek information from you could change. So there may be a well-defined process around it. More checks and balances could come in, which would be a great thing. But other than that, I don't think there's anything else that would likely change.
I mean, so basically no changes for enterprises in
Yeah,
that.
yeah.
Thanks. Yeah. So, I mean, the next question is around, SDF, because the law specifically mentions that they'll be informed, right? But it's been, I mean, almost 3+ months. We're entering the 4th month after the notification for the rules. The classification is still not out yet, at least in what we know of. So, do you see this delay as a concern, or do you think it's deliberate regulatory pacing? What is your opinion?
Okay, so I have a personal opinion and I have a professional opinion. But anyway, what I'm just going to tell you is through informal channels, I mean, informally, general officials in the ministry have conveyed that they are mindful that SDF has additional compliance obligations. They are mindful that businesses who will ultimately be declared as SDFs need to plan differently, or they would need that additional time to comply. So even if, let's say, the overall provisions of the law kick in by May 2027, which is the timeline, right? But until and unless there is a prescription for who an SDF is, it is not possible to comply even though that provision is implemented. So the idea could be that they are deliberating this. They may not have a timeline in mind just yet. But as and when they come out with the SDF classification, the time period for those additional compliances could be more than May 2027.
Okay.
For those additional compliances only.
Okay. I think that's an interesting take, but okay.
Yeah.
I mean, yeah. So, just letting the others know as well. So we have a Q&A chat. So please feel free to drop in case you have any questions. So I'm going to in the meanwhile pick up a question. Okay, basically we ran a poll. We asked what is your biggest implementation worry to the team here. So the maximum vote has come across for data processor or vendor compliance. So basically, the third party compliance is what is worrying data fiduciaries. How do you see this, and how can somebody address this?
Okay. Uh, okay. I'll tell you, this is an interesting one because I advise both processors and fiduciaries, and I can say that the worry is real. And it's real from both sides, to be honest. So, anyone coming to us to make sure they are compliant obviously is because they are serious about it, but very often the counterparty is not always serious about it, or they've not started their compliance journey. So the idea is that today you may enter into new relationships. They may not be compliant as on date. But the right questions to ask are, where are you in your compliance journey, not are you compliant? Are you taking this seriously? Have you assigned budgets to do this? When do you intend to be compliant by? So these are important things, and maybe it's also good to know who is enabling that compliance. So if they have engaged a third party, is it someone reputable? Again, depends on the scale of your own business, who your vendors are, what their budgetary constraints are, all of that. Keeping all of that in mind, at least you should have comfort in while you're onboarding vendors to know that they will be able to comply when the time comes. So even if they are not compliant today, you should be assured that they will be able to meet that compliance. Secondly, contractual protections will become very important, very critical. Uh, Processors are not directly liable under the law. So the only thing standing between a penalty for a processor's breach is your agreement with that processor. So you have to make things very watertight. If you have to put in step-in rights for defense control, all of that has to be built in. And plus, you need to do, if you don't already have a process, you should have an onboarding, vendor onboarding process in place, which does some base level of diligence. That in itself will, tell the other party how serious you are about it. And the more this happens in the market, the more everyone will understand why this is important, and probably they will start taking things more seriously then. So there is no immediate solution for this. It's going to happen over time. But yeah, as a business, you have to be careful about who you're onboarding. So please ask the right questions and maybe do a follow-up check-in. So if a vendor has told you, okay, we're not compliant today, give us a year. Check in January, what's the status? So check it in February, what's the status? Uh, if you don't do that, in fact, that could be seen as a risk to you because, look, under the law, you have to have reasonable security safeguards. Safeguards is not a standard. It
Yeah.
is the incremental practices you do as a business. So not having a vendor onboarding diligence could be seen as negligence on your part. So not following up could be seen as negligence. So those are things, and the law is very open to interpretation, right? So the authority can take these views.
I mean, I probably will ask a follow-up question of from a discussion that I had, with one of the data processor, right? So, I mean, I'll try to split the contractual obligations into
Yeah.
two pieces. One is about, the security of it, having the minimal security safeguards in place around access controls, encryptions, whatever is, required. Now, the second part is when in the contractual obligations, the data fiduciaries are also passing the penalties, that potentially could be levied on them to the data to the data processors. Now the data processors are kind of in a situation where they can't say no because they need the contract, but they can't take up a larger penalty, a monetary penalty on them. So it's a dilemma, rather it's a situation that has to resolve itself, but we have to see. I mean, what is your opinion or take on how this is going to turn out?
Look, I don't think it is fair to put an open-ended penalty on the processor. But having said that, because it is not always the processor who may be at fault, right? Maybe the data that has come to them could also not have come from the right sources. So ultimately, how I see this going is that each party will put in relevant protections and representations from their respective sides. And only if there is a breach of their own obligations, their own representations, would an indemnity or should an indemnity kick in. So maybe the scopes of those indemnities, liabilities of whatever is uncapped will change. And, it will eventually be limited to whatever is a limited breach in the context of the limited responsibility. So ultimately, you will pass on less and less information because you'll keep getting pushback from processors. You may not always want to send as much personal data or do a data dump. Maybe you will anonymize some things. Maybe you will put in alternative IDs within your organization and then pass on information based on those alt IDs to the relevant processor. So these practices will emerge. It's not just going to be a contractual fix. Eventually, you will reduce what you pass on so that the risk of any non-compliance is much lesser. Or if the vendor has access to information, you will have stronger controls in terms of what they can and cannot do with that data. You will want to be very clear about it, very transparent about it. If they are onboarding a third party or a subcontractor, you will want to know, maybe your consent should be sought. So those are all things that will pan out. Sorry, Yuvraj, you're on mute.
I think that's very interesting because we're talking about things evolving, right? But I hope it actually does in terms of less and less amount of data being actually shared or transferred, or that actually is a expectation of the law itself.
Yeah, that will, I think, ultimately be where things lead to, depending on how, again, enforcement takes shape, right?
So, I mean, I have one more question from our last webinar. We had a webinar last week. It
Yeah.
was more like a knowledge sharing question, but it came as a Q&A. So the person asked, okay, the credit information companies, right? I mean, we're talking about Sibyl, Experian, Crifimark, like companies. So as individuals, or rather, let's say Yuvraj's consent is not required by the bank which has provided me with the loan to share this information with the CICs. Now his question is there any way I can actually stop the data going from the bank to the CIC because I have not provided the consent, and I want to withdraw, the option of sending that information back to CIC, and it's a personal decision, right? I mean, the question is this a legitimate interest, or I mean, how do you see this entire question? To be honest, I was stumped when I was asked this question because I didn't have an answer, but I'm asking you. Yeah.
So I just want to make sure I got the facts right. So there
Yeah.
is an individual who has applied for a loan.
Yeah.
So he does not want his application data to go to the CIC.
It's an ongoing loan. Let's say I have a loan. So what happens is all the CICs get information on whether the EMI are right on time, right? So delays non-payment reduces your score.
Okay, so this is an existing loan. It's not just
Yes.
an application, basically.
Yes.
Look, I think there are banking prudential norms as well, which require, certain categories of information to be maintained. CIC is also a regulated class of entities. So, effectively, they have to maintain certain kinds of data. Rather, banks have to ensure that they are doing credit checks which match the requirement of the prudential norms and banking regulation that applies to them, banks or NBFCs, whoever it is. Sometimes they may need to engage outsourced service providers to do something like this. So within reason, I don't think this can be stopped, to be very honest, because CICs may be seen as outsourced service providers. And look, there are also exemptions under Section 17 which talk about processing of personal data for the prevention, detection, investigation of offenses. So if there are financial frauds, etc., one can potentially lean on that if there is enough cause. Secondly, if it relates to a default and recoveries, then also banks can share informations with third parties. So these are things they can do, and even at the time of customer onboarding, they have to do a risk check, right? So there has to be a risk scoring check, which is where the CIC provides that information. So they are mandated under law to do a risk check, and the data points kind of relate to past loans, past defaults, etc. So it's impossible for a bank to meet that obligation without doing these checks. So I don't think it will be feasible for an individual to say, look, I don't consent, unless and until they no longer. I mean, yeah, it's very difficult in this example. I mean, there are variations probably where a user may be able to say no, but not in this particular use case.
I mean, that actually helps. So I mean, I'm just switching between questions that I keep getting, right. So I was talking to a head of credit cards on one of the scheduled commercial bank in India. So basically his question was, they do a lot of these pushes. Basically, you have an existing credit card, you get this SMS or email saying that now you can increase your credit limit. Let's say it was 1 lakh, you can make it 2 lakh by doing a couple of steps, right? And you get this email. Now the question is that he was asking me is this a legitimate interest? Because he's a credit card customer of mine, right? And I mean, and I have consent for some purposes. Now, I don't know if I have to ask specific purpose that can I send you an upgrade or a credit limit upgrade, or is it okay to send it already, and it's up to the person's decision whether they want to proceed ahead or not. So yeah.
Okay, so generally, look, this is not, I won't say it's a objective question, to be honest. It is very subjective, but I'll tell you this much. Legitimate use only covers the purpose which is specified in the notice, and the purpose that you specify has to be directly related to the activity that is happening. Because look, if I take a credit card, it is my reasonable expectation that I will be contacted for that credit card. If there's anything associated with that credit card, I will be contacted. But if someone tries to sell me a loan on the basis of that credit card or insurance, that is not something which I I would cover under legitimate use. There should be separate consent for something like that. But if it is in relation to my credit limit of an existing credit card, yeah, it's a service I've taken, so it is a reasonable expectation to be contacted about it.
I mean, I'll try to improvise on this question. Let's say, tomorrow Apple releases 18, right? And now this is, let's say, a luxury HNI kind of a credit card. Now, can I send them, an offer that's specifically for these HNI credit card holders that, it's a promotional activity. You can use a credit card and get some extra discounts on purchasing, or getting quick access or faster access to the phone itself, right? Or you get it 1 day early or whatever. So is this part of services as well, or is it more of a promotion?
If it's a value add for the same product, again, very subjective answer. I can't, like, don't take this as gospel because I've not seen the terms, I've not seen what the product is or whatever. But if it relates to the same product offering, maybe it is reasonable to do that without consent. But if you're trying to sell a new product line, I would think not.
Okay, I get the answer. So, I mean, we spoke about SDF not being informed, right? And an extension to that is consent managers are supposed to be licensed, but the licensing process is still not started. Now, the question among some of the players in the market is, I mean, since there is no licensed consent managers, do we wait and decide who do we go with? Or I mean, they just have to take a gamble on whoever they feel is the right fit. So wait.
Yeah, wait.
Okay.
I definitely suggest wait.
But again, yeah.
I'll also tell you two things, right? Again, this is based on consultations, conversations with relevant stakeholders at the ministry. Ultimately, all the consent manager architecture will interact with each other. That's the only way to make this successful, because one consent manager may not have all the accounts of every data fiduciary. So you will, and look, when I say consent manager, there are two aspects here. One is a consent manager, which is going to be registered with the authority, like you said, and they will service the data principal. So principal will be able to use that consent manager to manage consent across multiple platforms. So I have 50 apps on my phone. I have given different permissions to all of them. This consent manager platform, whenever it is registered, licensed by the authority, will enable me to manage my consents across all those 50 apps through that one consent manager app. So this consent manager is servicing individuals to manage their consent across platforms. But there are consent management tools in the market which are in-house tools that the companies can use to manage. I won't call them consent management tools, I'll call them data management tools. So they are tools that companies can use internally to manage their own compliances, their own implementation. That is not regulated. That
Okay.
you should feel free to go with whatever is the right fit for you. But some of these entities may also be getting a consent manager license for the other use case that I spoke about first.
Okay.
So maybe it will be a good fit to go for a combined offering if possible. Maybe you'll get a better rate out of it. I'm not sure. But I think that these two are completely independent, generally speaking. And anyway, the consent management, the consent manager platform, which will be licensed, cannot undertake any other business activity. So technically, they may not be able to do it from the same entity anyway. So yeah, I mean, I think it's safe to decide what in-house tool you want to use. But when you have to integrate with the consent manager, wait for the person to get a license first.
I mean, I think you touched upon three sub questions that I had, so I'll probably try to ask that, and I think we are almost reaching the threshold. So in case anybody has a question, it's now is the time. I mean, please feel to add it. So I'll try the three questions that I have, right? So the first question is, so today, I mean, the way I see the ecosystem, right? So there's data principals, there's data fiduciaries. So let's even say there are data processors, even though indirectly regulated, but I'll say still they're regulated, right? Now the consent managers, I'd say they're regulated because they're going to be licensed. They have obligations. There's going to be monetary
Yes.
penalties. So basically, everybody, a defined stakeholder, is all regulated by the DPP, Data Protection Board of India. Now, when we say you use an internal tool, the data management tool, let's say, which is on the internal side of things, you use it because you can't build it, yourself, kind of. They are unregulated, so which means the owners of the tool going wrong will fall completely on the data fiduciary, right? I mean, how do you see this equation? Because it's the only unregulated piece in this entire ecosystem.
Yes. Yeah, you're absolutely correct. See, there are many. Okay, firstly, tough question to answer, but I'll try. I'll take a crack at it. First and foremost, you're absolutely right. It is the data fiduciary's responsibility. So it will then become critical to see, like I said, is this an on-premise solution? Is it a solution which involves access by this agency which is providing the tool?
Okay.
So first and foremost, you would want to limit any kind of third-party access to the maximum extent possible to the actual personal data which is underlying whatever the tool contains. So a business would need to ensure that. That's number one. Number two, when you talk about something going wrong with the tool, I presume you mean a glitch where maybe a consent did not get recorded, or a notice which was sent did not get recorded, and tomorrow someone raises a complaint, you have no proof to demonstrate. Yes, that is a risk. Unfortunately, I'm not a technical person, but any tool which has a glitch like that, it could be, a very critical miss, to be honest. So everyone should verify the efficacy of the tool they are onboarding, and which is why test out different things, whatever is in the market, see what suits your requirement best, but do maybe you can do proof of concepts, right?
Okay.
uh, Maybe you can do a testing phase with different tools that you have shortlisted. That should definitely help. But yeah, ultimately it will be your responsibility. The only way the company can protect themselves is ultimately contractually in this situation.
One last question. I know I mean, if you have time, so one last question, and we'll try to wind up. So we will take some of these questions that has come up for maybe for the next session. So because I don't want to lose a line of thought that we are discussing, right? So you mentioned about conflict of interest. Now, I see that as a danger today from where I sit, because the trends that I see are not aligning, right? Number one, data processors are raising investments, getting into this business of consent manager. Number one. Number two is, I'll not name them, but there are two public sector banks that have an RFP. Some of them closed, some of them out in the open, where the RFP is for both auditing, an independent auditor of DPIA plus a consent manager, one kind of a RFP for one company to take up. So again, I see the dilution here, because consent manager along with assessment or an audit, right? So and I mean, I can try to add more, but then this is the trend that we are seeing. So from your opinion, as a lawyer, how important is this conflict of interest clause, and how much important, rather, what would your advice be for data fiduciaries in terms of handling this?
Okay, I'm not fully sure I understand the question, Yuvraj, but what I gather is when you talk about conflict of interest, you mean the same entity doing dual functions, which is offering a database management solution as well as.
Okay, a data processor in some sense. So, let's say KYC
Yeah.
company is getting into doing consent management, or an auditing company,
Yeah.
doing consent management. So, how do you see that? Yeah,
So when you say consent management, again, this is the licensed activity or the tool?
we would assume licensed activity, at least from
Okay.
the
Okay.
positioning of it today. Yeah.
Got it. Got it. So yeah, that would, I mean, I would think that that should not be allowed. Maybe they should house those two businesses in different entities, because a consent manager generally needs to be data blind. So if someone is auditing anything, they will obviously get access to a lot of data. And yeah, I don't think that is going to fly in the long term. So maybe RFPs are being given out, but maybe the businesses will ultimately be housed in different entities. I'm not sure who has gotten these RFPs, but yeah, that's
I
the
mean,
way I would see it.
thanks. I think that thanks for adding this. I think we'll probably take up more of this in the next session. But thanks for doing this, Shreya. I know spending 1 hour, especially on a Monday, it's not easy. Thanks a lot for doing this. I hope the team hearing this would definitely I have some takeaways and probably reach out to you. I mean, I'll do drop them
Yeah.
your contacts, or they can reach out to you over LinkedIn in terms of follow up questions. But thanks a lot. I think this is a lot of clarity in terms of specifically gray areas that we have today. So thanks for this. Yeah.
Thank you, Yuvraj. Happy to have done this. And yeah, I hope everyone did indeed find the session useful. I mean, these were very insightful questions. I had a lot of fun answering them. So uh, thanks for inviting me.
Thanks everyone. Thank you. Yeah. Bye.
Thank you. Bye.